what Mr. Weigel wants to do is he wants to come into court with some of his own filings. He may want to come in with an affidavit of specific negative averment. He wants to come in with a motion to set aside default judgment. He has a 90-day window to do that under most circumstances. It can extend beyond that under some other circumstances. That's primarily what he wants to do at this point in time. And so that it would be his hearing coming in here with the bank showing up because he's trying to get default judgment set aside so that he can start fresh from the pre-answer position and then give response. That's what this hearing would be. And it really would be nothing more than the legal argument between whether or not he has a legal position to obtain default judgment, or the bank has a legal position to have its default judgment enforced.
Let's hear how that goes verbally. That's what we need to hear. How would they go verbally between you two? As both back.
Roast each other when you know.
Well, we can do that, and it might be educational, but it really is not in the tenor of what you guys have been learning the last day and a half. That would be my only hesitation at doing that.
Well, I understand the. I didn't correlate the fact that even though it's a civil action, it would be better if, in this regard, if it went to trial. Let's say he's made an answer to the bank, and now we have a trial on the proofs, rather than in default.
Okay, but again, I don't think you would go to the tenor of what you've been trying to teach these people.
Well, I do, because in the context of you're going to bring forth, he asked a very good question, or he asked me a very good question. Do you have a security interest or a security agreement in this case? Well, I don't know. I'll have to check the file.
Okay.
Okay. Now, if he's put this case on a UCC and he's done a search and the bank isn't on there, guess what?
Kiss the bank goodbye.
Okay. Do you want to set the parameters? We can go through
Well,
that.
I'm just saying, I mean, there's all kinds of possibilities, and maybe we need to, before we, take up a bunch more time, maybe, set the parameters back, think through a little more of a process to set it up, and deal more with a ticket. I'm just saying that in a trial situation, there wouldn't be, he was treating it like an arraignment,
Right.
I was treating it like a
default judgment.
A default judgment, and so that's where the confusion is he thinks he's being arraigned when he's not. That's why I'm saying he's got to come into the courtroom.
Right.
Okay? And so I was trying to get him to, and I didn't express this, but I was hoping that he would come in more of a litigant standpoint where he has answered, and now he wants to ask for my claim. He says, do you have a claim against me? Well,
Why don't we do that with a ticket then or something like that?
yeah. All right. I'll be the prosecutor. We're in a criminal case here.
Okay, the court will call the case. It's traffic infraction, Municipal Court of Tacoma. The plaintiff, the state of Washington, versus Beacon. That's Patricia Beacon. Is Patricia Beacon in the court? Patricia Beacon?
I'm here in regards to that matter.
And who are you, please?
Well,
Would you please state your name?
may I have your name?
Well, I asked you to speak your name, please.
Well, I'm here in regards to the matter of Patricia Becken.
Are you Patricia Becken?
Well, I'm here in regards to a matter with Patricia Becken.
Are you representing Patricia Becken?
I don't have enough information or knowledge to accurately answer that question.
Well, this is a matter of, actually, this is a civil matter on this citation.
Yes, Your Honor, that's correct. It's an infraction of the Washington Code.
Right.
And the state's position would be that if Ms. Beacon does not appear, that default would be entered against her and fines and penalties assessed.
Do you understand the position of the state on this, madam?
I cannot make a legal determination.
Are you represented by counsel?
I don't have enough knowledge or information to accurately answer that question.
Have you attempted to hire an attorney in this matter?
I don't have enough information or knowledge to accurately answer that question.
Have you shown your copy of this citation to an attorney?
I don't understand the nature of your question.
Do you speak the English language fluently?
Well, I can't make a legal determination on that.
Your Honor, this is obviously, you know, I'm beyond words, Your Honor.
Well, Counselor, I find that an unusual circumstance.
Yes, Your Honor, I fully appreciate that. Your Honor, I would move that if this individual is not going to identify themselves to the court, that number one, they either be asked to leave the bar or identify themselves to the court or risk being held in contempt, Your Honor, for taking up the court's time in a obviously frivolous fashion.
Well, Patricia Bacon has 15 days to respond to this citation, and I don't believe notice has been sent by the clerk that a notice of non-appearance. I think that I'll instruct the clerk to issue a notice of non-appearance to Patricia Bacon and hold this matter over then for it to be resolved on that notice.
Thank you, Your Honor.
Court's adjourned.
How'd I do?
Well, again, you should have turned right to me and said, "What's your name?"
Claim. Oh, okay.
Okay. Again, if he's and rarely is the judge non-responsive because he's gonna give his name. Okay. There's been a few times when that kind of thing has gone on, especially early on.
Should she give her name?
Well, I don't have a problem with what she did.
That was
But
great.
I think she did really well. But as soon as I interject and speak up, as soon as that, you gotta look at it like this, okay? Picture the judgment seat of God, okay? And you're standing before the throne, and guess who's over here? Going, okay? That's what he's doing. And yet, that's I heard the word accuser. That's the accuser over there. And whenever he speaks, you got to say, "What's your name? Do you have a claim against me?" Because you don't. And that's the picture that's represented here. Yes?
But if she never identifies herself in any way, how can she ask if there's a claim against her?
Well,
I mean, in what capacity?
she said, and that's a good question, in what capacity can she ask if there's a claim? She said she's here in regards to that matter.
She should say, is there a claim against Patricia Bacon?
She could say, is there a claim against Patricia Bacon?
Sam, you had a good response the other day. You said, I can't make a legal determination.
I can't make, she said that.
Are you talking about the creditor or the debtor?
That's correct.
That's a good answer.
That's a good answer.
But you left an opening to once there too, when you said what the charge was. Couldn't she said, well, I accept that value?
Yes,
Right,
she
so
could have said, I've accepted that for value, why am I here?
Exactly.
And then I could have come back and said, who is she, Your Honor? And you would have said, who are you?
Well, she hasn't identified herself. How could she make the statement?
The way I handle it is when I say I'm here in regards to that matter, and they insist that I give my name, rather than risk failure to appear or contempt, I will say my name is capital S, small a, small m, small u, small e, small l. And I just go through the whole thing. Now, or I could say, are you speaking to the creditor or the debtor? You've got to go through a process of determining, and only you can judge what that response will be based on what is he going to do? Okay?
So she's supposed to get up there and say, this is Patricia Bacon, uppercase, lowercase letters. I am here as a third party to represent Patricia Bacon, all caps.
No, I don't go into the third party thing. Typically, the response is, the judge gives his name, and do you have a claim? And the judge will say no, and do you know anybody who does? And he'll say the state. And so then the person turns and says to the state. Okay?
So she shouldn't say that I'm the creditor here in this matter, here are my papers. And
She could.
that's what should be done, right?
Again, there's any number of ways you can approach it. That's fine. If you want to bring forth your creditor claim, that's fine.